the court is trying to resolve this on like the most kind of tentative ground possible by saying that the challengers just failed to make a solid facial challenge, and nobody except, I think, Justice Kagan wants to get too definitive about when a platform is an editor and who's not. But that's really where the debate is here.
It's the Lawfare podcast. I'm Kevin Frazier, assistant professor at St. Thomas University College of Law and a Tarbell Fellow at Lawfare, with Anupam Chander, Scott Ginsberg Professor of Law and Technology at Georgetown Law, Kyle Langvhardt, assistant professor at the Nebraska College of Law, and Alan Rozenshtein, senior editor at Lawfare and associate professor at Minnesota Law.
So what the court here is doing is saying, yeah, there are areas in which, a non-discrimination norm might be acceptable. Maybe that's constitutional in certain areas, but not in deciding between whether to platform Donald Trump or to platform, Hillary Clinton or Joe Biden.
Today we're talking about the Supreme Court's decision in Moody versus NetChoice and its likely ramifications on content moderation and continued state regulation. In Moody versus NetChoice, the Supreme Court aimed to resolve a circuit split arising from disparate treatment of state laws impacting how and when social media platforms could moderate content. Justice Kagan authored a unanimous we'll get into that, a unanimous opinion holding that neither the Fifth Circuit nor the 11th Circuit applied the right test and remanding for the proper application of the standard for facial relief. Justice Barrett, Justice Jackson, Justice Thomas, and Justice Alito all penned concurrences that, to varying degrees, accepted and rejected parts of the consolidated Kagan opinion. Though remands may sometimes be chalked up to as nothing burgers, this one turns out to be somewhat of a whopper of an opinion that will give our guests plenty to debate and discuss both now and for the foreseeable future. So let's get the hot takes out of the way. Let's do a quick lightning round. In 3 words or fewer, what's your reaction to this opinion? Alan, we'll put you on the spot first.
3 words or fewer. That's hard. Okay, I'm gonna do it, but I need to be able to hyphenate 2 of those words. So my reaction is more law review hyphenated articles, because although this opinion does dispose of, I think, some of the case, we have years of litigation and scholarship ahead of us on just how far this opinion goes. So more law review articles.
Okay, law review editors, you heard it here first. Expect a lot of NetChoice in your inbox, maybe even in the August cycle. We'll see what happens. Anupam, hit us with your 3-word reaction.
I only need 2 words, no hyphenation at all. Thank God.
Okay, I like it. All right. And Kyle, last but not least.
Big dumb litigation.
Big dumb litigation. Wow. Okay, you all nailed the assignment. I
think Kyle won that round.
I may have to work in some more lightning rounds. This is too much fun. All right. Well, let's get away from the fun stuff and instead go into the weeds. Alan, can you tell us a little bit more about this Texas law to begin with and the Fifth Circuit's ruling?
Sure. So the Texas law was enacted, I think, a few years ago. I don't remember exactly when. This was one of 2 high-profile national laws, along with Florida, that purported to limit what social media companies could do when moderating content. Companies like to call it moderation. The state governments that don't like it call it censorship. It's sort of where, depends on your point of view. The Texas law, I think, is most notable for imposing basically a requirement of neutrality, one might say, on content moderation decisions. So I think the marquee provision of the Texas law is that if you are covered by the law, and there are certain questions about who was in fact covered, and that I think explains a little bit of the opinion. If you're covered by the law, and think of the big social media platforms, and you choose to allow one particular kind of content about a topic, let's say you are okay with certain content about race relations or politics or international relations or Pokemon, it really doesn't matter what. You cannot censor any content on that topic. So you don't have to necessarily allow political content on your platforms. But if you allow for any political content, you have to allow for all political content. And the reason that this is so controversial is that on any topic conceivable, there are a range of views, some good, some not so good, and some downright ugly. And so the concern that a lot of people had with the Texas law was that it puts the platforms in a position of either having to allow all sorts of content on a particular topic, including really bad content, or to avoid the Texas law's neutrality requirement, just say, okay, you're not going to have any content at all on this topic because we don't want to be in the position of having to both sides it. And so the choice was either turn your platform into potentially a dystopian hellscape or suppress vast amount of speech because you want to avoid that requirement. So that's the substantive content moderation part of the Texas law. The Texas law also included a variety of transparency measures in terms of platforms having to explain on what basis they did moderation. So Texas passes its law. NetChoice, which is the industry association for all the big tech companies, sues. I don't actually remember exactly what the district court held. I think the district court upheld the law. But either way, when it got to the Fifth Circuit, let's call it aggressively upheld the law, basically saying not only did the law not violate the First Amendment, but that there essentially was no First Amendment issue because content moderation, which the Fifth Circuit viewed almost entirely as censorship, is not a First Amendment right because, if anything, it suppresses speech rather than encourages it. And so that was the posture that the Fifth Circuit, that the Texas case came up to the Supreme Court. And obviously, we can talk about the big smackdown that the Supreme Court opinion, Justice Kagan's opinion, does to, at the very least, the Fifth Circuit's very stingy interpretation of the platform's First Amendment rights to moderate content.
Okay, well, I am looking forward to the breakdown of the smackdown. But before we get there, Kyle, can you dive into the Florida law and the 11th Circuit ruling and the nature of this split that made its way to the Supreme Court?
Yeah, so the Florida law is, I guess I would say, a lot more busy. I don't know that I want to use the word nuanced to describe the Florida law, but there's a little more to it than the Texas law. It doesn't contain the same kind of viewpoint neutrality requirement that Alan was talking about. There is some language that says certain aspects of content moderation have to be performed in what it calls a consistent manner. So there's this undefined term, consistent manner. What really stands out about the Florida law is there are actually certain provisions that require the platforms to carry certain types of content in a kind of absolute way. So one aspect of the law is about political candidates. And it says that any speech by or about political candidates that occurs beginning on the date that the candidate qualifies and ending on the date of the election, all of that speech has to stay up on the platform. Another thing that it says is that journalistic enterprises can't be moderated. And journalistic enterprises here is defined very, very broadly. So it's entirely in terms of like the volume of content, the size of the audience. One thing that the law's challengers pointed out was that the site Pornhub would qualify as a journalistic enterprise under this law. Well, under the Florida law, a platform couldn't moderate any kind of journalistic enterprise under that definition because of its content. So that's, I think, the big difference. I'd describe Texas law as a viewpoint neutrality law and Florida's law as a law that's primarily concerned with leaving certain types of speech by certain types of institutions up on the platform, essentially no matter what.
Anupam, what was the 11th Circuit's reaction to the Florida law? Why was there a difference in holding in comparison to the, quote, aggressive holding of the Fifth Circuit as described by Alan?
So the 11th Circuit was more skeptical of the Florida law. It believed that it was a violation of the First Amendment rights of the platforms and that this was directly speech that the platforms were being asked to modify by the state of Florida. And so it sided very largely with the platforms, with NetChoice and with the Computer Industry Trade Association in that regard.
Right. So the key issue here is that the posture before the Supreme Court was that neither of these acts had actually been enforced. So we're dealing with a facial challenge here. And now getting into the weeds of Justice Kagan's opinion, her primary focus is that both circuits erred in applying the proper test for a facial challenge, and that they treated it more like an as-applied challenge rather than what this facial posture requires. So Anupam, let's stick with you. What's her description of the test that should have been applied and what was actually applied at the circuit level?
So I think in the lower courts and for much of the litigation, this wasn't really a big issue. No one was really thinking of, is it an as applied? Is it a facial challenge? That wasn't the main focus of the argument, because the challenge was to the main core of the statutes. The core of the statutes was an effort to change the content moderation practices of these platforms. And all sides had in mind the kind of big platforms and their content moderation as we typically understand it. Their decision to kind of promote or demote content, to ban users from, to ban certain speakers from their speech platforms, etc. And the Supreme Court said, no, in fact, you need to make sure, because this is not an as applied challenge. This isn't a challenge that is to a particular action as applied to a particular defendant or a particular set of defendants. It is a facial challenge that says the statute as a whole is unconstitutional. And that requires a different standard than the courts below tried to use. And so the Supreme Court here, Justice Kagan writing the opinion for the court, sending it back to the lower courts for determination as to whether or not it survives, the statutes can survive a facial challenge. You know, in some sense, this is a little bit of a hard, Net Choice has the burden here to demonstrate that the laws are facially unconstitutional, but the court also gives Net Choice and the Computer and Communications Industry Association, CCIA, support in this process.
So, as Justice Alito pointed out, the counsel for Net Choice are, quote, sophisticated counsel. They've read all the case law. They've read all the relevant precedent. Alan, is it surprising we saw this opinion? I mean, shouldn't we have hoped that the council would have expected this sort of pushback? Why did we get to the Supreme Court with an insufficient record, given the millions, if not near billions of dollars spent litigating this case?
That is an excellent question. I mean, I will say a couple of things. So first of all, I'm with Anupam. You know, I don't think anyone thought of the facial versus as applied issue, or at least no one was really flagging it before this got to the Supreme Court. It was not in the briefing. It was a huge part of the oral argument. So I think once oral argument happened, then we all kind of knew this was coming. So why are we so surprised? I mean, A, it might have been a mistake, but B, you know, the Supreme Court is making a big show of how different as applied are to facial challenges, and they are. But the Supreme Court is also happy to consider facial challenges all the time, and they're happy to, when they want to, treat a facial challenge as an as applied challenge or vice versa. So, you know, they're being a little precious, I think, about saying, you know, how dare you bring a facial challenge? This should have been an as applied challenge this whole time. Kagan is not wrong, obviously, in this. What I think actually happened is when it got to the Supreme Court, everyone realized how hard of a case this actually was to think through in all of its complexity. And they all started looking at it. You can just imagine what happened at conference after the oral argument, which was incredibly long. I remember being just so exhausted after 4 hours of this. And you can imagine all the justices looking at each other and waiting until someone says, but maybe we could just kick this off, kick this back, because this was brought facially when it should have been as applied, and everyone just nodding their heads vigorously. So I think there's a little bit of that going on here, which is people didn't quite realize until oral argument how complicated this would be, at which point really focusing on the facial versus as applied part started making a lot more sense, because that's a way that you can kick this back, say some things, but deal with the problem down the line. I will just say, you know, Although I can't help in reading this opinion today think about last year's almost opinion and non-opinion in the Gonzalez Section 230 case, where again you have this just like unbelievably giant lead up, an incredibly messy oral argument, and a resolution of the case that really doesn't address the merits and is on totally other grounds. Because again, I think the exact same thing happens, which makes me wonder, why is it that of all the issues the Supreme Court has to deal with, whether it's immunity or Section 3 or abortion or affirmative action, social media content moderation is like the thing that these 9 geniuses who hold themselves in very high intellectual regard just cannot handle year after year. But I will get off my high horse now.
That sounds exactly right to me. I mean, for years, I've been trying to write pieces that try to take kind of First Amendment principles and apply them to a kind of hypothetical law that might regulate content moderation practices to bring them into a sort of substantive agreement with free speech principles. And every time I do it, I just kind of wind up in this state of despair because it's just so complicated. So I think Alan's description of the problem seems entirely plausible to me.
So I think that's right. And so if I can just pick up, so I agree with Alan and everything he said. I think when the justices start looking at this and say, hey, Reddit and Gmail and Facebook Messenger and Uber, wait, what are we doing here? Do we know at all what the rules should be? Is there a kind of one rule to rule them all in this context? I mean, even if it's the First Amendment, how do we interpret the First Amendment in these such disparate contexts? And so I think the court was probably thought it wasn't going to be as hard. We'll decide the circuit split between these two courts. But then suddenly, as Alan says, when it's seized of the matter, it realizes, oh boy, there's also this transparency bit of this, which is extremely complicated and no one has really thought through. So what of these laws should survive? And part of the problem was that it's not so there was a lot of blame put on NetChoice for not having decided clearly who was covered, what these laws did. I think no one knew exactly what the laws did. That the word social media was defined so broadly as to encompass a lot of stuff that really wasn't the goal of the laws. And so if Uber's covered, if Discord is covered, Etsy is covered, is that really what the Florida or Texas lawmakers were concerned about?
And here I just have to shout out Justice Alito for mentioning even Be Real. I want to know if Justice Alito has a Be Real. I want to see him during oral argument, have to take a quick selfie, send it out to his Be Real followers. I'm just waiting for that moment. Clearly, he has to have one.
His clerk clearly has a Be Real and knows, has shown, presumably, hopefully has shown the justice how Be Real works. And a really important question as to whether that Be Real has kind of expressive qualities in it. But Be Real probably has a lot of content moderation going on behind the scenes as well.
Well, speaking of what constitutes inexpressive activity, this was a big subject of debate among the concurrences as to what sort of content moderation might cross the line into inexpressive activity. So, Kyle, can you help us think through how the justices were exploring this idea of inexpressive action in the context of content moderation? For example, Justice Barrett pointed out that there may be some sort of spectrum with respect to the use of AI in content moderation activities where, in a completely automated effort might not be expressive at all, whereas some hybrid system may maintain that idea of expressive moderation. So why does this matter, and how are the justices thinking about it?
Well, I mean, it matters a lot because this idea that platforms have this kind of editorial right to moderate content is what the whole case is built on. I'm one who's always been a bit skeptical of extending this metaphor of a newspaper editor to social media platforms. I mean, to me, it's a concept that you can stretch it far enough to fit, but at some point, I think a social media platform starts to feel a little more like some kind of private regulator or something like that. I guess I would say that Justice Kagan's opinion pretty much described these kinds of editorial rights in the same way that I think just about anybody would have expected up until, I don't know, maybe 2019 or 2020 when it seemed like maybe these kinds of issues were being debated a little more intensely among lawyers. Justice Barrett is saying, hey, this stuff might be kind of complicated. Some of these content moderation practices might have more expressive salience than others. I think Justice Alito goes even a little bit further in that direction, saying, hey, maybe if you have a platform that is putting up 95% of what it receives and only taking down some small percentage of what it receives. And if there's no human being who could possibly look at all this stuff, maybe we've stretched the editorial principle too far. Now, the court is trying to resolve this on like the most kind of tentative ground possible by saying that the challengers just failed to make a solid facial challenge, and nobody except I think Justice Kagan wants to get too definitive about when a platform is an editor and who's not. But that's really where the debate is here.
And just to count votes for a second, because I think this is important, and maybe it's useful just to sort of step back and kind of just describe the architecture of the opinion. So you have Justice Kagan writes the majority opinion for 5.5 justices, which is to say she writes a majority opinion that disposes of the case on this facial versus applied challenge and says, lower courts, redo this, but do this properly this time. She gets 6 justices on board with her opinion, and then the 3 justices in concurrence, though it's kind of like it's a concurrence in the judgment, basically, agree with her on that. But she also spends a bunch of the opinion saying, but we'd like to give you some guidance on the actual First Amendment standard to apply when you do this. And that part of the opinion actually is only signed on to by 5 justices. So her and 4 other justices. Justice Jackson, interestingly, declines to sign on to that opinion because she says that's just dicta, right? This opinion is about facial versus applied. I don't want to sign on to a merits thing about the First Amendment. Now, that part of Justice Kagan's opinion, and we can get into details about it, is very kind of traditional editorial rights. It's basically the Tornillo opinion from, I think it was the 60s or 70s, about newspapers, kind of the opinion that started this whole thing, applied very straightforwardly and very strongly to social media platforms. Okay, so you might think, okay, well, now we know what the Supreme Court's going to say, right? Because they basically telegraphed what they're going to say. But not only do they not get Justice Jackson on this, it's not clear they get Justice Barrett either. Because although Justice Barrett signs on to this 5.5 justice opinion, she then writes this concurrence saying, yeah, just to be clear, I think Tornillo applies here in some kind of narrow standard way, but there are all these interesting issues, right, related to AI and algorithmic moderation that I would want to reserve for later. So, the way I think about this opinion, kind of the bottom line is that, the molten core of the Texas and Florida laws, right? Those parts of the laws that say if some human being, some content moderator at Facebook picks out a piece of content and decides to, quote unquote, moderate or censor it because they just think it's toxic, right? That is First Amendment protected because of Tornillo, right? But beyond that, we don't honestly know what the answer is because Kagan, although I think we know what Kagan would want the answer to be, I don't think she has 5 votes, or she doesn't yet obviously have 5 votes for the 50 future fact patterns. So when, Kevin, you asked me at the beginning to sort of sum this case up in my reaction, and I said more law review articles, that's what I was referring to. There's going to be this mess, I think, of state laws testing every inch of this opinion, and then a bunch of law review articles, right, written by probably many of the people in this video call, trying to figure out, okay, we know that Tornillo applies to social media companies. Okay, that is now essentially settled. There's definitely 5 votes for that, right? That was always probably the right answer in some general sense. But exactly how does it apply? What counts as expressive content in terms of content moderation? That is very, very much up for grabs. Again, not so much to save the kind of vulgar core of like the Texas law, which was basically always there aren't enough conservatives, we're unhappy about that. But like that was never the really interesting part of this debate anyway. It's all the stuff around it that is truly interesting and is very much wide open.
So if I could jump in on that vulgar core, the vulgar core, of course, was what the political debate was about. And so these 2 statutes were both enacted in 2021, right after the deplatforming of then former President Donald J. Trump. And so lots of people on the right in particular in both state houses angered by that deplatforming and the deplatforming of other fellow travelers. And so that, I think there's a solid majority, as Alan says, on this court that says, hey, that is core expressive activity. The decision to kick someone off your platform, the decision to demote them is your expressive compilation and thus First Amendment protected. There's nothing in the opinion that suggests that there's any hope for surviving that kind of First Amendment scrutiny on those if it's applied to those facts. And that's the core. So I think in that sense, this is a huge loss for Texas and Florida because the reasons they enacted these laws were not to show that the platforms can be regulated and they have to be neutral in their messaging services or in the Ubers that they offer, or they can't discriminate invidiously on those fronts. That wasn't what they were alarmed about. That wasn't the core question. So what the court here is doing is saying, yeah, there are areas in which, a non-discrimination norm might be acceptable. Maybe that's constitutional in certain areas, but not in deciding between whether to platform Donald Trump or to platform, Hillary Clinton or Joe Biden.
I think the part of Kagan's opinion that like Justice Jackson is referring to as dicta, where Kagan seems to actually be laying down a lot of doctrine, even though supposedly this is just an opinion about facial challenges. And I think a lot of what she's responding to there is the Fifth Circuit's opinion just being like totally off the wall. So the Fifth Circuit's opinion below on the Texas law really didn't use like ordinary First Amendment tools to resolve this case. So the Fifth Circuit was pretty steadfast in saying that if a platform is censoring speech, it's just flat out not speech. So they're not saying like there's a dim expressive interest or a kind of subtle expressive. It's just like this is just flat out not speech. There was this major strand of the opinion that was about this kind of like history and tradition kind of common carriage doctrine. So that states have this history and tradition of setting up common carriage laws, and this history and tradition of common carriage laws basically entitles the state to like an exemption from ordinary First Amendment doctrine. I mean, this is really kind of off the rails stuff. And so I think to the extent that the majority seem to be laying out a good bit of explanation of how these editorial principles work, I think it was trying to just sort of steer the Fifth Circuit back into the kind of mainstream of First Amendment thought, even if there are a lot of questions that remain unresolved. I don't know if that was your reaction too.
It was, Kyle. And the only thing I would say is, a lot can happen between now, though, and the next time this gets up to the Supreme Court, right? The composition of the court could change. Even if it doesn't, people's views just evolve. At the end of the day, what Kagan, that part 3C or C2 or whatever, that part of the opinion where Kagan goes and does kind of a bunch of black letter declaiming of the doctrine, that is dicta. Right? It is in fact dicta. And none of the justices that signed on to that need to feel bound to that next time this comes up. So, all I would say is, although I do agree with, Anupam that the signal from at least 5, maybe 5.5 justices right now is that, Texas and Florida kind of badly overreached in what they tried to do. I would just be very cautious about trying to predict what will happen in 3 years from now. Or 2 or 4 years from now, which is, the length of time it's going to take for this to recirculate up the courts, because you never know. I mean, there are plenty of cases in Supreme Court history where you have, one case and then a few years later there's another case and it seems like the same case and yet the outcomes are extremely different.
Mm-hmm. That's happened I think in this litigation to some extent. I think the expectations were very different, a year ago, even than they are now.
I do think that this going back to something that Alan said, is so interesting that the court chose this kind of procedural or technical question to focus on, as opposed to but added as Alan has described it, the dicta for further instruction. But interestingly, there's a question. I'd be curious what happens here after this. Are the laws enforceable, or where does it leave the rule? Because the platforms have to decide what to do.
I mean, so correct me if I'm wrong, everyone. My read is that the laws are in force, and that net choice is going to what it was today. I've lost track of time. Today's Monday, and that on Tuesday or Wednesday, when people are listening to this podcast, net choice is going to march into the federal court in Texas and Florida and refile these lawsuits, but just on much more narrow grounds, saying, we represent large traditional social media platforms that have algorithmic news feeds, and our first priority is to say that these news feeds are First Amendment content moderation decisions are First Amendment protected, and we'll deal with all the other issues later. That's what I assume, or alternatively, they can wait for Florida and Texas to enforce these laws. If I recall correctly, the Texas law is enforced by the Texas Attorney General. The Florida law, I think, has some private enforcement as well. Maybe I'm reversing them, but the different laws have different enforcement mechanisms. And they could, of course, just wait until Texas or Florida try to enforce those laws and see what happens then.
I'm really fascinated by this expressive argument, especially with respect to the use of AI content moderation. When we think about how the vast, vast, vast majority of content decisions are made, it is by AI, at least for these larger platforms. And to the extent there is any, quote, human in the loop, they're in the loop for all of a Planck time second. They're there for 5 seconds, they look at it, and boom, it's gone. So whether or not that's expressive, and to Justice Alito's point, he wants to see that the use of editorial discretion is towards some sort of, quote, collective point. What is the collective point that Facebook's making when it's going through its newsfeed? What is the collective point that YouTube is making when it's directing those thousands of content moderators around the world? So to Kyle's point and to Alan's point about how this case will evolve in the interim, I actually think that more evidence about the use of AI is going to reduce the idea that this is somehow an expressive activity, the more we see moderation being used. Alan's shaking his head. Anupam's ready to jump in. I stirred the pot. I love it. Anupam, tell me why I'm wrong.
Justice Barrett hints has that hint, right, in her concurrence. Is it different if hate speech is moderated by AI, which it currently is, right? But maybe even more so in the future, as Justice Barrett seems to suggest. I think in all these cases, the hate speech is defined by Facebook, taught to their algorithms. And so it's just the automation of Facebook's expression. That's what's going on. And I don't think that makes it any less Facebook's expression.
So the one other point I want to jump in here too is that Justice Kagan seems to think that part of the expressive nature of this activity is that users, quote, may well attribute to the platforms that the posts convey their expression in toto. Do we buy this argument? I do want to point out here that assertion has no citation. She also has no authority when she claims that the platforms, quote, own their overall speech environment. So she's somewhat resting this argument on users identifying that Nazi post or that hate speech to Facebook itself. No citations were provided. So I'm just curious, are we buying this argument?
But let's imagine, so Elon said, hey, Nazis, come back on, right? And many people left because they thought, hey, that's X. X is now a platform I don't want to have any truck with, to borrow Kagan's language from her opinion. So I think the reality is that we do feel like if the platform allows for, anti-Muslim speech, anti-Semitic speech, women's speech, etc., the platform is making a choice. And some people will say and when they say we don't want that, that is their expressive right. And that's what the majority very strongly, at least in the sections that Justice Jackson doesn't fully embraces.
So I think this is exactly this discussion is exactly why these issues need to be resolved on as applied rather than facial grounds, because it gets so fact specific so very quickly. I agree with Anupam that automation by itself should not render something non-expressive, right? If I type something on a computer, the output of that, even though there's a bunch of automation and processing happening behind that, is I think, less expressive than if I were to, write that with a quill on parchment. So that, I think, isn't the issue. At the same time, though, I do think that Alito is right, or at least is onto something when he says that for something to be expressive, there has to be something you are expressing. There has to be kind of a point of view and a perspective. Now, if the point of view and perspective is, hey, here are specific kinds of hate speech we don't like, I think that's a perfectly coherent view, and therefore it is expressive, and it's expressive whether or not you use automated or non-automated tools. And it is true that you can train an AI to be very discriminating, right? To be a classifier and be very accurate. At which point, I think the AI can be said to have encoded your expressive point of view. The problem, and I take it that this is what Barrett is saying in her concurrence, and I think this is what's particularly interesting and is really important for not Texas and Florida style regulation, but future regulation involving data privacy or addictive design or children, which is, as we continue to use algorithms to filter, sort, moderate, these are all essentially the same thing. And if we just give them kind of a general reward function, which is to say increase user engagement, and we have no idea how to increase user engagement, right? But we just know that you should increase it by feeding people things they like and that doesn't offend them too much. And the algorithm then does that. Is that expressive? What exactly is Facebook expressing at that point through this algorithm that has, billions of parameters, trillions of data points, is constantly changing, by the way, right? Day by day, it is adapting to user preferences. What exactly is it expressing other than some generalized, we want users to be happy? I'm not sure. I don't think that's the kind of expressive viewpoint. Again, I can't speak for Justice Kagan. I don't think that's the kind of expressive viewpoint that, let's say, a Justice Barrett thinks should be protected by the full arsenal of the First Amendment. And I think that is a particularly interesting question.
It's a great point, Alan.
Yeah, to go to Kyle real quick.
I mean, I think one of the most unfortunate things about First Amendment law today is that there's no clear boundary around this concept of speech. It's such an abstract concept that the domain of cases where you can say that somebody is speaking is just enormous. And I think what I would hope as this case law develops is that maybe judges begin to take some of the emphasis off of this question of whether someone is expressing themselves or not, or whether a company is expressing itself or not. And I would hope that it would move more of the emphasis to the actual kind of interest balancing that takes place after that. Now, this isn't really I think the feel of American First Amendment law right now, but it seems to me that the question of whether a given platform is expressing its own views when it moderates millions of people's content is just not the most important thing going on. I would rather have courts take a look at the implications of this kind of content moderation system for the entire system of free expression and weigh the public interests in regulating against the company's private interest in speaking by moderating content.
And one of those areas where Justice Kagan was maybe stepping out over her skis just a little bit with respect to dicta land was on this idea of the state interests in these different laws. So Texas, for Justice Kagan, she says Texas has not been shy and has always been consistent in its stated interest of maintaining balance. And she very much says, I don't really buy it. I don't see a huge interest there. What did you all make of this proclamation issued by Justice Kagan in that regard? Let's go around the horn. We'll start with Alan.
Yeah, honestly, that bummed me out. That part of the decision was the one that kind of made my heart sink. I mean, Justice Kagan just cites to Buckley versus Vallejo, the famous campaign finance First Amendment case, in which the court says, and I'm going to paraphrase here, it's just not a legitimate government interest to try to balance people's speech powers in the marketplace. Not, it's a dangerous thing. We're only going to allow it a little bit. It's really hard to overcome. It's just not a legitimate interest. And I think given what the First Amendment has wrought in our campaign finance law over the last 20 years, given the regulatory ends to which it has been taken, at least in my view, often very excessively, I think it is unfortunate for this opinion to cite to that really, I think, troubling and overbroad statement without any nuance, without any recognition that there really are imbalances sometimes in the marketplace of speech, and that there may very well be an important role for the government to play in balancing that. Now, again, none of that would be to take away the dangers of that or how narrowly tailored it has to be. And one could require lots of showings from the government that it's doing a good job. But I think to just foreclose that as a legitimate government interest at all is, to be honest, quite short-sighted. And I think that it will come back to this. This is the sort of language that can come back to bite, I think, the progressive allies of net choice, who I think were rightly quite skeptical that Texas and Florida were acting in good faith. But I worry that in doing so, net choice and through this Justice Kagan opinion has won a bigger victory for the sometimes called the deregulatory or Lochnerized First Amendment than really needed to happen here.
Kyle, any thoughts on this interest question before we go to Anupam?
Well, yeah, I mean, I also always get a little depressed when I see this kind of citation to Buckley, that it's antithetical to the First Amendment to try to balance the speech interests of some against the speech interests of others. I would rather not see the court write that off as just a completely illegitimate speech interest. Now, I do think there's a question if there is a substantial speech interest in leveling, which the court rejected here. But if there is a substantial speech interest, there's a question of whether the law will actually accomplish that leveling well without doing all sorts of collateral damage. Those are the kinds of questions I would prefer to see the court asking. There was some language, and I don't have this in front of me right now, but I think Justice Kagan did allude to many possible substantial interests that regulators might point to in regulating social media platforms. I think maybe 2 or 3 of these opinions referred to kind of public health interests and protecting teen mental health, that kind of thing. I am interested to see what kinds of substantial interests would qualify as permissible bases to regulate if this interest doesn't.
So let me begin by saying I think Justice Kagan is largely right on this issue. Okay, I don't know about the campaign finance stuff. I'll keep out of that thorny set of questions. But here she says, in order to obtain the government's view of a speech nirvana, quote unquote, the government shouldn't change what speech happens on these platforms. I think the dangers that she's referring to are in fact evident in these 2 sets of laws. The laws talk about discrimination, but what they're talking about is discrimination against their favored political friends, that, they want to have recourse against the platforms. And so this isn't really, it's a kind of their view of what a speech nirvana looks like is one that says, you can't get rid of InfoWars. You can't get rid of the people who are spouting vaccine disinformation. You can't get rid of, election deniers or people who might even be fomenting the next violent uprising, as long as they aren't doing it in sufficiently to be inciting that violence. And so I think this does, this isn't a demonstration of of her concerns. And so she actually, when she says, the worst way that we can do this is actually a worse danger, that allowing the government to create a speech nirvana and endorsing regulation to create a speech nirvana is actually the greater danger than the lack of the speech nirvana that is asserted. So I think that's a very practical argument, and it's based on history, and it's exemplified in these two statutes.
So I think one through line we've seen from y'all's commentary as well as from the concurrences is that the next case that may make it to the Supreme Court is likely to be even more complex. For example, if we're diving into the weeds of the expressiveness of AI content moderation. And Justice Kagan herself described the court as not the 9 greatest experts on the internet. So are we just going to see this sort of continuation of maybe the justices finding the easy way out? In short, are we just witnessing this tech aversion manifesting again and again, as Alan hinted at in his first remarks? Alan, why don't you give that a stab first?
I mean, I hope we don't see tech aversion, or it depends on what you mean by tech aversion. If tech aversion leads to a bunch of incremental rulings over the next 10 years, I think that'd be great. I would rather I think this is an area that is ripe for good old common law constitutional rulemaking, where courts, little by little, puzzle through this stuff. They try to say as little as possible. They recognize that this stuff is important and technology is evolving, and they take kind of little bite by little bite. I would rather a bunch of, and not just because I get to write law review articles about it, I really think it would be better if the court in the next decade just, has a bunch of First Amendment, digital First Amendment cases. It does 2 or 3 digital First Amendment cases a year for the next several years. They will gain expertise. They will gain confidence. There will be a process by which they can put out ideas, get feedback from lower courts and academics, revisit that if necessary. What I think you want to avoid is the sort of like once every 10 years, this big case comes up, the court says something oracular and then submerges back into the mists. And I think, unfortunately, that's a little bit of what we kind of had. I think you saw that, for example. Obviously, this Section 230 case isn't a First Amendment case, but it implicates kind of all the same issues. You had that a little bit where, the court took almost 30 years to decide the Section, to even take up the Section 230 issue. Its approach to digital First Amendment cases has always been very patchy. I think it's time that the court treat this a little bit more like it treats, ERISA or bankruptcy law, where like every year there are just 2 or 3 of these cases because this is an area that just needs a decade's worth of development. That's what I would advocate for.
Kyle, did you have a comment there?
Well, I mean, at some level, I wonder whether courts as institutions have the bandwidth to address these kinds of issues. I mean, there is just so much diversity among different types of platforms. Within any given platform, there is so much diversity of modes of content moderation that they might use. Just the volume of cases, if you think of each post as a case, is just orders of magnitude beyond the volume of litigation that courts have looked at throughout the kind of First Amendment tradition. I mean, what I've always thought, and I think I don't think this is exactly like the zeitgeist at the Supreme Court right now, but I've always thought that if there was any public institution that was competent to confront these issues, it would have to be agencies. That courts just don't have the bandwidth to do this. And I kind of wonder if in this case, maybe this litigation is a symptom of that. I think even these laws themselves out of Texas and Florida, I don't think these are the best possible laws on this issue. I think these are actually pretty dumb laws, like very, very, very flawed laws. But I think one of the most basic flaws is they just rely very heavily on litigation that puts these kind of disproportionate pressures on platforms. And yeah, I'm fairly pessimistic, but I do think incremental is definitely going to be better than this.
So I have to say, I agree with Alan, but disagree with Kyle. So let me explain why. I agree.
Anupam, you've always had excellent intellectual taste.
So I think both of us, Kyle also agrees with Alan on the incremental question. I think it's good that the court was incremental, that it didn't opine on the vastness of internet speech. Right. But on the other hand, I think that Kyle's kind of preference for agencies is alarming. And so in this context, do we really want agencies to be making a lot of specific regulations about internet speech? That sounds a lot like the Ministry of Truth. And by the way, those agencies, might be run by Trump, or they might be run by Biden, or whomever it might be, right? I can imagine all kinds of shenanigans in that process, and I think that's truly problematic. So I'm happy to, I think Justice Kagan here really strongly says the government should not be in the business of doing rewriting the community guidelines for these internet platforms, and that core business is, entirely the determination of the platforms. So I think that's actually really important, incremental but fundamental step forward. It also says to the people who are saying it's all a common carrier, everything goes, you can't. It's this is the new public forum and, kind of shopping mall where you can say what you want, you can leaflet what you want. It says, no, that's not going to work either. So those kinds of, broad approaches of, which some people championed in this case, I think are really put to rest by this court. So I think this is incremental, but it's still significant. It really just reasserts traditional approaches. It says, unlike what some folks here might, like I think Kyle again, would prefer, these are a lot like newspaper publishers for their core function. And that is protected by the First Amendment. We don't care whether or not it's done by X or done by Facebook or done by the New York Times. So I think in those ways, the court has moved the ball forward substantially.
Well, I have about 15 law review articles to get started, so we're going to have to leave it there. Thanks for joining.
Thanks very much, Kevin.
Thanks.
The Lawfare podcast is produced in cooperation with the Brookings Institution. You can get ad-free versions of this and other Lawfare podcasts by becoming a Lawfare material supporter through our website, lawfaremedia.org/support. You'll also get access to special events and other content available only to our supporters. Please rate and review us wherever you get your podcasts. Look out for our other podcasts, including Rational Security, Chatter, Allies, and The Aftermath, our latest Lawfare Presents podcast series on the government's response to January 6th. Check out our written work at lawfaremedia.org. The podcast is edited by Jen Pacha, and your audio engineer this episode was Noam Osband of Go Rodeo. Our theme song is from Alibi Music. As always, thank you for listening.